Today's meeting is taking place in a hybrid format pursuant to the House Order of June 23, 2022. Members are attending in person in the room as well as using the Zoom application. I'd like to make a few comments for the benefit of the witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, do click on your microphone icon to activate your mic, and please do mute yourselves when you are not speaking. Interpretation for those on Zoom is at the bottom of your screen, and you do have a choice of either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. In accordance with our routine motion, I am informing the committee that all witnesses have completed the required connection tests, correct? Thank you. Now, pursuant to Standing Order 1082 of the motion adopted by the committee on Wednesday, September 21st, 2022, the committee resumes its study of Canada's sanction regime. It is now my great pleasure to welcome as witnesses before our committee, first of all, Mr. Brandon Silver, who I suspect is well known to you all and is a Director of Policy and Projects at the Raoul Wallenberg Centre for Human Rights. He is joining us by video conference. We also have witnesses from the Canadian Bankers Association. We have Stephen Alcez, the Global Head of Economic Sanctions at the Royal Bank of Canada, as well as Ms. Angelina Mason, the General Counsel and Vice President, Legal and Risk from the Canadian Bankers Association. Now, each of you will be provided 5 minutes for your opening remarks, after which we will open the floor to members so they can ask you questions. And we will go with Mr. Silver first. You have 5 minutes. And once you're getting very close, I'll put this up. Would be grateful if you could attempt to the best of your abilities to conclude your remarks. So, Mr. Silver, the floor is yours. You have 5 minutes.
Thank you, Chairman Assassi, honorable members. It's a pleasure and privilege to see so many friends and familiar faces, and I bring warm regards from Honorable Professor Erwin Kotler, who regrets he couldn't be with you today, but very much endorses the content of our center submission. Merci pour l'opportunité de vous joindre.
Thank you for the opportunity to join you today. It is my pleasure to testify as a lawyer and policy director for the Raoul Wallenberg Centre for Human Rights. Our institution has been very involved in the development of Canadian sanctions systems as well as in their implementation. We also manage a global coalition of nearly 400 civil society organizations that work for sanctions and that promote human rights.
Global leader in safeguarding dignity and democracy by strengthening the use of targeted sanctions. This committee study presents a most propitious opportunity to chart such a path forward. It is especially timely as Putin's illegal and unjustified aggression against Ukraine is giving violent expression to a broader authoritarian assault on the rules-based order and those who seek to defend it. Targeted sanctions have proven to be a powerful tool in pushing back. The visa bans, asset seizures, and business dealing prohibitions that these sanctions entail are isolating the architects of repression, turning them into global pariahs, and cutting them off from the financial flows that fund their oppression. These sanctions are also protecting Canadian sovereignty from the corrosive effects of corrupt foreign capital and from the rights abuses of those who would seek to co-opt and undermine our democracy and financial institutions. So it therefore ensures that our markets and our economy are not contributing to these abuses or acts of aggression abroad. These are all, honorable members, measurable successes. Indeed, Canada's adoption in 2017 of our Magnitsky Law was a game changer. It lowered the implementing threshold for autonomous sanctions from quote unquote a grave breach of international peace and security that has resulted in or is likely to result in a serious international crisis to now also include gross and systemic human rights violations and acts of corruption. Accordingly, our center uses the term Magnitsky sanctions to refer to actions taken pursuant to these post-2017 lower thresholds under both the Justice for Victims of Corrupt Foreign Officials Act and SEMA. So with these measurements and new thresholds, out of over the 2,000 targeted sanctions that have been implemented since the adoption of Magnitsky laws in 2017, 482 of these are Magnitsky-style sanctions for human rights abuses and corruption. So that means that out of roughly 35 Magnitsky jurisdictions, this makes Canada a leader in Magnitsky implementation, a close second to the United States, and far ahead of every other jurisdiction. And that's all the more admirable when you consider that we have a fraction of any of their resources. However, that being said, Magnitsky decisions are overwhelmingly undertaken unilaterally and without structured cooperation amongst allies, despite the shared interests, values, and threats that we may all be seeking to address. In a practical way, this can result in asset flight, with a sanctioned individual laundering their ill-gotten gains and conducting their business in another parallel jurisdiction upon being sanctioned in Canada. It also lessens the significant rhetorical and reputational value, as the listing can be presented as a singular aberration amongst the more reasonable democracies rather than an achievement in the pursuit of justice and accountability. Therefore, the Wallenberg Center suggests that an international contact group of jurisdictions with Magnitsky laws should be established, which would greatly assist with the coordination and multilateralization of sanctions implementation, while also creating a forum for the sharing of best practices. As well, Canada should take a whole-of-government approach to sanctions and create a single focal point to ensure interdepartmental cooperation and cooperation amongst allies internationally. And this is well grounded in parallel precedent. If you look at the US with the Treasury Department's Office of Foreign Asset Control, with the UK, with the State Department's Special Envoy on sanctions, I think there's a lot of great models that we can be following internationally to ensure that we continue to lead. And we could assume a leadership role and unique convening capacity internationally to make sure that Canada's sanctions policies advance our foreign policy priorities. For example, we can use sanctions to give teeth to our leadership in advancing the declaration on arbitrary detention and state-to-state relations, and thereby shift the calculus in hostage taking. And we can also, at a time when the rules-based international order is under assault and multilateral institutions are being undermined, we can use our sanctions regime to show our confidence in these institutions and the enforceability of these international norms by using decisions of UN special procedures like the UN Working Group on Arbitrary Detention, or international treaty monitoring mechanisms like the Committee Against Torture as the basis for the implementation of sanctions. But, and I will conclude with this, honorable members, an especially important refinement to our sanctions frameworks would enshrine the crucial oversight role of all of you here today. Ultimately, some of the most impactful precedents and policies have been proposed by civil society and pursued by Parliament. Formalizing this relationship would only strengthen it. Our center's written evidence to the committee elaborates upon these proposals, in particular the final one, drawing upon existing parliamentary precedent and practice, like order paper questions, tabling of public petitions, and the like. And we'd be pleased to discuss with you either in the Q&A or in greater depth separately from this committee hearing. But I'd like to conclude by thanking all of you for your important work in guiding Canadian foreign policy and the opportunity and privilege to testify before your committee today. Thank you.
Thank you very much, Mr. Silver. As I understand, we will now go to Ms. Mason. Is that correct?
Mr. Chair, could I just raise a point of order? Would it be possible for us to get unanimous consent to work through, I think there will be bells shortly, to continue to work through that?
Is that the will of the committee? Yeah? Yes, correct. Absolutely. Great. Thank you, Ms. McPherson. We now go to Ms. Mason. You have 5 minutes for your opening remarks.
Thank you. Thank you for inviting the Canadian Bankers Association and the Royal Bank of Canada to appear this morning to participate in the committee's review of Canada's sanction regime. My name is Angelina Mason, and I'm General Counsel and Senior Vice President, Legal and Risk with the CBA. I am joined today by Stephen Alsace, Global Head Economic Sanctions with the Royal Bank of Canada. Recent proposed legislative changes and federal budgetary commitments in the sanctions space highlight the federal government's continued commitment to the laudable policy goals that drive the regime: safeguarding of human rights, combating significant corruption, and preserving international peace and security. Banks operating in Canada have invested heavily in their efforts to comply with and thus enable the evolving regime. Our members work extensively with Global Affairs Canada and the RCMP to ensure broad compliance with sanction requirements. They also have in place systems and procedures for managing sanctions risk and conduct active screening against sanctions lists. The government provides valuable support for this work. We appreciate GAC's consolidated Canadian autonomous sanctions list, the increased willingness of GAC officials to engage with stakeholders, including our members, on sanctions matters, and their efforts to perform public outreach. Further, the federal government's announced investment of $76 million in GAC's development of a devoted sanctions bureau and additional support to the RCMP is an important initial step towards ensuring the growing regime is properly resourced to function effectively and efficiently. Given their role within the global financial system, our members have observed several ways in which Canada's sanctions regime should continue to evolve. Primarily, as the regime continues to evolve and become more complex, including the recent proposal of deemed control provisions that contain highly subjective elements in Bill C-47, there is a need for written, publicly available guidance. This need is well understood. It was highlighted by this committee's 2017 report, as well as in the Senate Standing Committee on Foreign Affairs and International Trade's recently published report detailing its review of the regime. It is also common practice for sanctions authorities in other jurisdictions, such as the United Kingdom and the United States, and in other regulatory contexts within Canada. To address this need and align with international and domestic best practices, we encourage GAC to develop this written guidance in consultation with stakeholders. Guidance will provide clarity and transparency for stakeholders, especially those that lack or cannot afford access to expensive resources to support their activities, thus mitigating the operational and regulatory risks that may flow from regulatory opacity when doing business globally. It will also help to ensure that the Sergei Magnitsky Law and CIMA are implemented as intended and their desired policy goals are efficient and effective. Along with written guidance, as endorsed by the Senate Committee report, the government should also work to educate the Canadian public on the nature, rationale, and impact of Canada's sanctions laws. In the current context, private sector entities, like our members, are often required to address the questions and concerns of their clients. To ensure the public receives accurate, up-to-date information that is consistent, we suggest the federal government would be best placed to answer these questions, as our members and other stakeholders are still trying to understand the impact of the law on their own businesses. There is also currently an opportunity to improve the efficiency and effectiveness of sanction reporting. More specifically, our members currently provide sanctions reports to various government agencies. The government's recent proposed amendments in Bill C-47 to create additional reporting requirements to FINTRAC opens the door for meaningful engagement between the regulator and industry to refine reporting requirements to ensure they meet the policy intent of the legislative amendments. Operationally, the permit system also requires the federal government's attention. We understand that in other jurisdictions, there are streamlined mechanisms for seeking permits or certificates to authorize certain specified activities or transactions that are otherwise prohibited. For example, the United States has provisions for general licenses that authorize particular types of transactions for a class of persons without the need to apply for a specific license. This general approach has not been used in Canada, although it is possible under the law. Given the lack of guidance and clarity in the law, we understand GAC has been flooded by permit applications. It appears this increased volume has created a backlog of applications, leaving Canadians waiting with unclear timelines for formal responses. These permits are not always sought by large corporations. Often it's everyday Canadians seeking these permits, such as retail banking clients attempting to remit funds to family members in jurisdictions impacted by sanctions. We suggest GAC align with the approach taken in foreign jurisdictions. Further, we also recommend GAC hire additional resources to focus specifically on license application and ideally sets out a mandate to complete all license requests within a reasonable period. Finally, as the Senate report recommends, sufficient investment in GAC's Sanctions Bureau and other federal partners involved in the regime is needed. We appreciate and support the government's previous budgetary commitments to GAC and understand the government is considering providing additional government agencies with a role in the sanctions space. Given the complexity of the regime, it is critical that any government department or agency involved in the regime, including GAC, is properly resourced and that staff receive extensive training on and have sufficient knowledge of this highly technical area of law. This approach will help ensure oversight is tailored to and reflects the uniqueness of the regime, that is not conflated with that of other legislative areas, such as Canada's anti-money laundering.
Ms. Mason, if I could ask you to conclude your remarks, you're a minute and a half over.
My apologies. Thank you. We look forward to your questions.
Thank you. You'll have an opportunity to mention all the things you wanted during question by the members.
You caught me in my last sentence.
Absolutely. So we now open it to questions from the members. The first member up is MP Hoback. You have 5 minutes.
Well, thank you, Chair, and thank you, witnesses. Ms. Mason, I'm going to go to you first. You talk about written guidance. Maybe just expand on it a little bit. Right now, when you're dealing with somebody, let's say a Canadian business that's looking at doing business in another country, what is there for you to provide for guidance? And would that, because there's no guidance in place, is it possible that they get advice or different advice that would be from one institution versus another? Just give me some...
Sure. Compared to other jurisdictions, guidance is very detailed. It goes into specific fact scenarios, definitely a lot more structure, and therefore people can interpret the particular sanction differently, and guidance is the best way to ensure that there's clarity and consistency in approach.
So wouldn't that be for the courts to define, or is that something that should actually be right in the legislation?
Guidance is actually very commonplace, not only within the sanctions area, but other regulatory areas within Canada, whether it's OSFI or the Consumer Protection Framework. It's very common for regulators to add guidance to what's in a particular statute or regulation, because necessarily there will be fact scenarios that you just can't contemplate within the four corners of a piece of legislation.
So what are the consequences for you then if you do make a mistake because you haven't been provided that guidance?
Well, I mean, that's why we are very wanting to ensure that guidance is provided, because what ends up happening is then you end up not being able to proceed in abundance of caution because there isn't clarity for exceptions. And we have sought a permit, we have assisted our clients in seeking permits, but you know, it's the two sides of the same coin. If the guidance is better, there's less need for permits, but otherwise people are having to apply for permits to understand whether or not their transactions are permissible.
Okay, thank you. Mr. Silver, great, and I just want to say we really appreciate you and your organizations and Mr. Coulter's work in this file. You talk a little bit about asset flight, and I'm just kind of curious if you had some examples of what that looks like. And then you talked a little bit about a single focal point to prevent some of this. So maybe just give it a little bit more texture or content, if you don't mind.
Sure. Thank you, MP Hoback, for your kind words and important questions. So if we look at Magnitsky multilateralization, so the idea that with imposing sanctions, the asset freezes and visa bans should ideally be coordinated amongst multiple jurisdictions with parallel laws. If we were to sanction an individual in Canada, and we are the only country to do so, they can easily make use of parallel banking systems, the very same amenities and rights that they seek to deny their compatriots at home and enjoy those rights abroad. The statistics in Canada are that 79% of our sanctions are unilateral. That means that most of the sanctions we're implementing are undertaking important components of naming and shaming and protecting our domestic financial systems and democracy from being co-opted or abused by foreign nationals or entities engaging in malign behavior. But it's less effective, again, because they can, go to the UK, the US, the EU, or any of the other 30 odd Magnitsky jurisdictions. And of the 21% of Canadian sanctions that are multilateralized, i.e., not just us, we usually only do it with one partner. So they're not very broad or multilateral. When we say that, we're not engaging unilaterally, it's really only usually bilaterally. So Canada will do an announcement with the UK or with the US or with the EU. So of that 21% of multilateralized sanctions, 14% of those are bilateral, meaning that only a couple percent of Canada's sanctions are truly global in reach and scale. And that sort of has a bit of a nexus with our recommendation to create this diplomatic coordination group. If Canada is engaging in a concerted and coordinated effort to share intelligence, to share Magnitsky implementation and diplomatic action with like-minded states, we can really tighten the screws and increase the pressure on rights abusers and ensure that both reputationally and rhetorically, because it would be multiple democracies sanctioning them, but also substantively in terms of depriving them of the ability to access the, vacations, universities for their families that they, seek to often make use of in Canada, the US, and the UK, the vacations, the banking sector, and markets and economies, that if we're acting concertedly, we can be far more impactful.
I assume I'm out of time.
And sorry, if there's some time, would you mind repeating your second question? I could address that as well.
MP Hoback is out of time. We now go to MP Ben-Dayan. You have 5 minutes.
Merci beaucoup, Monsieur le Président. Je comprends.
Thank you very much, Chair. I understand that we have another 20 minutes before we need to go to votes. Thank you. Thank you to the witness as well. Of course, Canada and with its allies, we have imposed unprecedented sanctions on Russia. Across all elements of their economic structure, our aim is very clear: to restrict access to funding for Russia. And in my mind, there's a very interesting element among what we've done. We have withdrawn the main banks of Russia from the international SWIFT system, and I'd like to hear our witness, especially those of the representing Canadian Bankers Association, on that issue.
Begin then with you on the SWIFT sanctions that Canada imposed with our allies. Mr. Silver just noted the importance of working with multiple allies. And in the case of SWIFT, we worked with a number of important allies in order to get that done. And I wonder if you could speak a little bit from your perspective to the effectiveness of those SWIFT sanctions.
Well, yes, those definitely had a chilling effect by having them removed from SWIFT. But it did create some challenges in the context of how to deal with certain impacts to Canadians. I'll turn it over to my colleague, Stephen Alsace, who can speak a little bit about what we were talking about guidance, some uncertainty that happens when you're not able to deal with certain banks. And it impacts on Canadians, yeah.
And thank you, Angelina, and Mr. Chair and members. Thank you for that question. Effectively, like we're removing some of the largest banks from Russian banks from SWIFT. It's choked off any transactions. Most of the Canadian banks no longer have direct access to Russia in terms of facilitating payments. But it's resulted in it's had a good effect in the fact that it's denied some of the larger banks like VEB, VTB, Sberbank access to Western capital. But it has had unintended consequences to ordinary Canadians. And that's part of the reason for a lot of the permit applications to Global Affairs Canada. Ordinary Canadians are no longer able to easily send money like remittances for child support, for example, to Russia, or to receive pension payments, or in the case of hockey players that are playing in North America, if their employer happens to be owned by a sanctioned entity, their payroll has been cut off. So that's, I think, one of the results that's occurred. One other point that I'll also make with respect to Mr. Silver's remarks, although we are very supportive of the Magnitsky sanctions, and we agree that greater coordination is important, just to note that most of the large Canadian banks have international operations. Or for us, for example, we have to comply with sanctions requirements in the United States, from the EU, from the UK, and other jurisdictions. So although it's not written into our law here in Canada, we do also honor other jurisdictions in which we operate.
Thank you. And have you seen rival systems emerging, alternatives to SWIFT?
Yes, like in China, there's the SIP system, and Russia has SFPS. In terms of the rise, I mean, we haven't seen significant traffic in that regard. But I think that in terms of alternatives to SWIFT, they are on the rise, and there's certainly that risk of capital flight away from that system.
Can you perhaps advise the committee of what else we could do to ensure that Russia is excluded from the Western financial system?
It's a bit challenging. A lot of it's diplomatic, right? I think it's like the focus on those jurisdictions, not necessarily the G20, but where we know there are jurisdictions that are sanctions evaders, right? The UAE, we're seeing, potential transactions through India, through China. So I think the focus needs to be, on some of those other jurisdictions.
Mr. Alsace, you had previously suggested that there's a bit of a struggle in providing regulatory guidance to financial institutions such as yourself. With the proposal for a devoted sanctions bureau, and I hear you, Ms. Mason, on the importance of these written guidance, but can you be a little bit more specific as to what exactly you feel you need?
Interpretive guidance, would assist. An example, if you look at the United States and OFAC, they've got something like 1,300 FAQs that have been published. Some of the interpretation, like around the proposed bill C-47, is looking at changing beneficial ownership, but rather than using an OFAC 50% plus one rule, they've elected to go even further than the EU and the UK. So when it's really going to make it complicated when you look at the control test that they're suggesting. So that's an area where we're going to definitely need greater clarification as the amount of due diligence that will be required. Because from an operational perspective, it will be impossible to stop every single payment and actually review it and exercise enhanced due diligence against it.
In a similar way, Mr. Alsace, it's also impossible.
Ben Diane, your time is over.
Thank you, Mr. Chair.
So we next go to MP Caron. Vous avez 5.
You have 5 minutes, sir. Thank you very much, Chair. I will put my questions to Mr. Silver. You have brought up Magnitsky-style sanctions, and you've said they've been a game changer. And you underscored, and I think that this applies to Canada, that there have been 442 sanctions in that style, the Magnitsky style. It seems to me that since 2018, when we used these measures against 17 Saudi citizens during that unfortunate event involving a journalist, that Canada hasn't used such sanctions since, or not as much. Is there a reason for that? Why a slowdown in using this type of sanction? Thank you for that important question. The number that our centre provided to the committee regarding the use of the Special Economic Measures Act applies to the overall approach to human rights violations and acts of corruption. So it is true that Magnitsky legislation itself was used a little over 60 times, but the changes that the Magnitsky Act caused to the Special Economic Measures Act has been such that our system of sanctions that now apply to gross and systematic human rights violations and acts of corruption can be used in a clear and more effective way to combat these violations.
Submitted 482 are those that would have only been possible post-2017. So before then, the threshold for sanctions were a grave breach of international peace and security that has resulted in or is likely to result in an international crisis. And that threshold change has allowed for a much more expansive use of sanctions that we think were rather timely given the global resurgence of authoritarianism, of illiberal populism, of acts of aggression The fact that those laws were changed accordingly is incredibly important. The disuse of the Magnitsky Law as it is, as opposed to the lower thresholds under the Special Economic Measures Act, is an interesting question that we explore in greater depth in our written submissions to the committee. It's our assertion that this is rather an issue of rhetoric than substance. The laws are largely parallel. There are some minor distinctions between them. The allowance for sanctioning of entities under CIMA, but of only individuals under the Magnitsky Act. But by and large, we actually call for, because of this, the shift in the use of language in order to allow for better coordination amongst our allies and to make use of the important resonance that the word Magnitsky has, that we call both CIMA and Magnitsky Law implementation for human rights and anti-corruption, Magnitsky laws.
I'll interrupt you only because we have little time, I'm sorry. You brought up multilateralism, saying that capital is very mobile, and you mentioned asset flight. When solely one country applies a sanction, assets can fly to other countries. Do we have any measures of asset flight that may have been caused by using these more unilateral sanctions? Do we have any actual examples of the efficacy of a sanction when sanctions were taken solely by Canada? The figures are difficult to establish, but we can get a feel for the circumstances based solely on the statistics that I have mentioned before to one of your colleagues. Most of Canada's sanctions are unilateral indeed. It's important for us, of course, to send out such signals to human rights violators to the effect that Canada will not tolerate such acts and will not sit back and do nothing, even if our allies feel they can't act on those specific cases. So we're not against unilateral imposition of sanctions. It's a good tool. Good example of federal leadership. For example, in the case of Vladimir Kara-Murza, he was heard before this committee several times, and his contributions were very important to our work on the Magnitsky Act. But due to that, he is now in prison, a 25 years prison term in Moscow for having testified before this committee. And therefore, Canada, of course, has sanctioned the legal system, the justices sitting in that case, the lawyers, and so forth, all corrupt.
Yeah.
Sure.
So,
sorry about that. You're 40 seconds over. Sure. So we're going to have to go to the next member. We will now go to Madam McPherson. You have 5 minutes.
Thank you, Mr. Chair. Thank you very much to all our witnesses for being here today and sharing your expertise with us. I think it's clear from all of the questions we've heard so far that everybody is interested in ensuring that Canada's sanction regime is as strong and as effective and as coordinated, I guess, as it could be. Certainly, Ms. Mason, I heard what you were saying about the challenges with reporting, the challenges with permitting, and Mr. Silver, when you talked about that single focal point, I think that's an excellent suggestion. Perhaps I'll start with you, Mr. Silver. Could you talk about that single focal point and whether or not, I mean, I know you're talking about it in terms of determining who is sanctioned, but in terms of the enforcement of sanctions, in terms of measuring the effectiveness of our sanction regime, would that also be useful in that manner?
Sure. Thank you for that question, MP McPherson. And that's exactly what we envision, and we elaborated upon it somewhat in our written submission. But if you look at parallel jurisdictions, not only is there an interdepartmental agency, such as a department with an interdepartmental responsibility for coordination, such as OFAC in the US or the UK's newly established office, there's an opportunity for Canada to do the same. The Budget Implementation Act announced the allocation of $75 million, the creation of a financial crime task force. So there's an opportunity there, perhaps, for this task force to have a interdepartmental coordination opportunity, but also one internationally. So when our allies are talking to us on sanctions matters, it seems to largely be ad hoc and subject specific rather than comprehensive and multilateral. Having a focal point can assist with that broader coordination and with coordination internally between the myriad and often regrettably disparate and siloed governmental departments, whether it be FinTrack, RCMP, STSIS, Department of Justice, GAC, and the like. Having that main focal point both within Canada domestically and for our allies internationally can help streamline things and address some of the issues fellow witnesses from the Canadian Banking Association have addressed. And in particular, the gathering of data have, because of these sort of diffuse nature of engagements, fallen to civil society. I mentioned in the outset of my remarks that we co-chair a group of about 400 major international NGOs working on sanctions. And the data and metrics I shared with you earlier were largely compiled by civil society because we've had to fill the void that should largely be played by government. The government should be tracking these numbers and using them as a means of refining their actions. And if I could use the remainder of my answer time, MP McPherson, because you've been a leader on Vladimir Kara-Murza's case in an all-party way. I know that MP Caron and his colleague Alexis Prunel-Dessep had joined in calling for freedom for Vladimir Kara-Murza, and I was referencing in my response earlier that that's a good example where we sometimes can't coordinate with allies, but we lead. Canada sanctioned all those involved in this case and then advocated with our allies to do the same. And it was one of those rare instances where the US Department of Treasury sanctioned in the Kara-Murza case, the UK sanctioned in the Kara-Murza case, and both of them in their public statements said, we are following Canada's lead. So that's one of those times where unilateral action helped combined with multilateral advocacy. Canada took the lead and all of our allies followed.
It's, of course, my deep honor to be able to be on that working group and to continue to push for honorary citizenship for Vladimir Kara-Murza. I do get your point, though, when you speak about the fact that there is sort of this ad hoc thing. We heard that from CBSA. We heard that from the RCMP in the last meeting, that there is no coordinated efforts, and it makes it very, very difficult. In fact, I've asked order paper questions that I've not received adequate responses from because I don't think there is those mechanisms in place. Perhaps for my last minute, I could just pass this over to Ms. Mason to just talk a little bit more about, you talked about the fact that global affairs is overwhelmed, that there is a backlog, that there is confusion. Could you speak a little bit more about how you would see that being fixed, how you would see that being alleviated?
Resourcing. And they're a very promising sign to see the devotion of such a large budget that will, through resourcing, when you have the expertise to be able to, again, provide the guidance, deal with permits. We also agree with our fellow witness, Mr. Silver, on ensuring there's coordination among all the different stakeholders within the government because they are various different aspects of the sanctions to make sure there's one stop where you have a fulsome understanding and as data and support.
Well, and I will say it's complicated for parliamentarians, it's complicated for banking, it's obviously very complicated for Canadians to understand this as well. So thank you very much for that clarity.
Thank you. We next go to Ms.
Chair, just a quick point of order. The convention is that we leave 10 minutes after a vote before we resume, given that we're all clearly voting by app anyways. I wonder if there'd be unanimous consent to resume the committee meeting immediately following the vote.
Is that the will of the committee? Yep.
Great.
Okay. Yes. So for this round, we have 2 minutes. Ms. Kramp-Nyman, you have 2 minutes, I'm afraid.
Excellent. Thank you. Just to complement some of the questioning from earlier, and Mr. Silver, do you believe or think that giving Vladimir Kara-Murza honorary Canadian citizenship would have an impact on his situation?
Thank you. That's an immensely important question, and we were in Parliament advocating for honorary citizenship for Vladimir because we believe that would offer life-saving protective cover. He is written from prison, mentioning that, and it also, as an aside, shows the effectiveness of targeted sanctions. His jailers, who were the same people who tried to assassinate him twice, and he miraculously survived, have not tried to assassinate him a third time because they know that the world is watching and cares, and those sanctions in his case helped. But there's a risk of that attention waning, of the acts of aggression and global crises shifting, showing that we continue to support this expression of Canadian values, that someone who testified before this committee and helped make our country's foreign policy more effective and humane, and the adoption of the very sanctions that we're discussing today deserves our solidarity and support just as a matter of shared values, let alone for the life-saving actions it'll give. Again, the jailers in his own prison have often said to him, and he's written about this from prison, that they ask, please make sure we're not included in Magnitsky sanctions. Please make sure we're not referenced in international statements. Those who are holding his life in their hands are watching what Parliament does, and adopting motion of unanimous consent to accord him honorary citizenship may very well help save his life, but will certainly be an expression of what this Parliament stands for.
Excellent. Thank you. Last question in the nature of time. With regards to the Magnitsky sanctions, how do you assess the effectiveness of the sanctions in comparison to other forms of diplomatic or economic pressure, such as traditional sanctions or targeted engagement? And are there any lessons learned or best practices that Canada can share with other countries considering similar measures?
Sure. Well, it's complementary, and we believe that oftentimes it can be used to advance Canadian foreign policy goals. We referenced earlier as a centre, and followed up in that in our written submissions, that, for example, in combating arbitrary detention, that targeted sanctions on those directly responsible for engaging in acts of arbitrary detention can help shift the calculus in hostage taking. It's something that the families of those being held hostages feel strongly about, and those like Richard Radcliffe and Nazanin Zaghari Radcliffe, who testified before this very committee some years ago, had been referencing as well that the combination of diplomatic engagement supplemented by targeted sanctions can help advance a country's foreign policy priorities. And that's one example. As well, domestically in Canada, we've got a national anti-racism strategy.
Mr. Silver, I apologize to do this to you again. We're going to have to move along because we're very, very short on time, and you're over time. We next go to MP Sarai. 2 minutes, MP Sarai.
Thank you. In light of my time, I'll go to Ms. Mason, and just some questions that probably haven't been asked. Are there measures that can be done to prevent innocent victims of sanctions from being harmed, particularly from the banking perspective? You probably see estates, families selling their estates, businesses who have sold goods prior to a sanction being made and then being paid and having their funds perhaps blocked. Are there ways and best practices you might have seen in other jurisdictions that our Parliament can learn from and I guess do to prevent innocent victims from being harmed under these sanctions?
Sure. So one example is in the U.S., where they, rather than having to do a specific fact case scenario permit, they do a general license. So they could have a general license that captures a general fact scenario that could then be applied to impacted Canadians. So something as straightforward as what Stephen had mentioned, or Mr. Alsice had mentioned about, pensioners being able to receive their funds, people receiving support payments, the estate case that you mentioned there, by having either a general license to deal with those scenarios, which allows a great deal of flexibility, or you have guidance, one or the other, you have guidance that will address those specific types of scenarios.
And are there any gaps in the Magnitsky Act that can be addressed, that can be done to fill in these gaps, these and on the reverse side of those that might slip in that are not covered by the Act itself currently?
It really comes down to ensuring that the policy intent is reflected. Typically, these sanctions are drafted quite broadly, which is appropriate. It's just then the nuance on interpretation, and consistent with other types of regulatory overview, regulators will provide guidance on what's not intended to be captured within perhaps broad language that on its face captures everything.
Thank you. We next go to Mr. Garon. You have a minute.
Merci beaucoup.
Thank you very much, Mr. Chair. I will continue with Ms. Mason. You've said a good deal about the lack of guidance for the application of the sanctions, which are written sort of in a broad fashion. I'm wondering whether you would be able to provide us with a brief with some basic ideas that could help us work out a solution to along the lines of what you're suggesting. I would like to see a list. I'd like to have you explain what sort of directives would help you carry out your day-to-day work applying the sanctions.
Examples from other markets.
Auriez-vous, par exemple, des...
For example, do you have any examples of comparable situations elsewhere that could guide us?
As my fellow witness had mentioned, there's over 1,300 Q&As in the U.S. side alone. So there are certain specific questions which, if they were to be included in an assessment of our sanctions regime, would be of great assistance.
Thank you. For the final minute, we go to Ms. McPherson. You have 1 minute remaining.
Thank you very much for that generous time allocation. This question is for our witnesses from the Canadian Bankers Association. In 2012, changes made by the then Harper government led to the sudden closing of Canadian bank accounts due to Ottawa's economic sanctions against Iran. Iranian Canadians who were affected, many of whom had no ties whatsoever to the Iranian regime, were quite frustrated at the time. Is this a problem that has been resolved in the past 10 years, or are you aware of ongoing problems whereby innocent Canadians' bank accounts may be included in sanctions? And if so, what's the remedy for this?
Stephen, did you want to take that one?
Yeah, I should take that question. Like, we're not aware that problem continues, and I think in part, it's the challenge had to deal with in 2012 the lack of guidance, from Global Affairs Canada and the interpretation of some of those sanctions. And that's why it's so important to have either written guidance or to make sure that we have ongoing discussions and dialogue with Global Affairs Canada to assist in avoiding those kinds of problems in the future.
That's my minute.
Yes, thank you. On the dot. So at this juncture, right before we vote, allow me to thank our three witnesses, Mr. Silver, Madame Mason, and Mr. Alcez. Very, very grateful for your time and for your expertise. I have every confidence that your perspectives will very much find their way into our final report. Very grateful. So we will suspend for the vote, and then, as was agreed by all the members, we will reconvene as soon as it's over. Everyone, we'll now resume our study of the sanctions regime, and it is my great pleasure to welcome several witnesses before our committee. We have as individuals Ms. Anaïs Cadian, an attorney, Ms. Erica Moret, the Senior Researcher and Coordinator of Sanctions and Sustainable Peace Hub, and a graduate of the Geneva Institute, and also from the government of the we have Mr. Zaw Kayao, who is a spokesman for the government in exile of the Republic of the Union of Myanmar. So each of our witnesses, I should let you know, you get 5 minutes for your opening remarks. After having heard from you, we will open it to the members for questions. So Ms. Cadian, we will first go with you, okay. And you have 5 minutes.
Monsieur le Président, merci. Honorable membres du comité.
Mr. Chair, thank you, and honourable members of the committee, good day. Thank you very much for the invitation to appear before you today. My name is Anaïs Cadian. I'm a civil and commercial litigation lawyer in Montreal, and my BA was in international relations. Recently, I've worked with other lawyer colleagues and human rights professionals to address the distressing situation of the Armenians of Nagorno-Karabakh. We submitted 2 briefs that were recently considered by this committee and by Global Affairs Canada. One in response to a review of export permits to Turkey, and the second about the status of Nagorno-Karabakh in international law.
The report prepared by the Civil Society Network, Haydn Partners for Humanity, submitted to this committee. It covers the important opportunity Canada has to respond concretely to the human rights crisis created in Nagorno-Karabakh through targeted economic sanctions against the Azerbaijani regime. Since this committee's mandate covers a review of, and I quote, the need for new recommendations resulting from Canada's response to the situation in Ukraine and other situations since 2017, Nagorno-Karabakh is one of these other situations where new recommendations should be made to Canada's response. In fact, the lack of concrete measures such as sanctions have unfortunately only emboldened the Azerbaijani authoritarian regime to continue violating international law and human rights without impediment. Some recent examples include capturing and torturing Armenian prisoners of war in the fall of 2022, as reported by Human Rights Watch, continuing to hold over 100 prisoners of war and subjecting them to inhumane treatment, continuously attacking and killing civilians in border villages and in Karabakh on an almost weekly basis, illegally attacking Armenia last fall, leading to hundreds of deaths and the seizure of 140 square kilometers of sovereign territory, and illegally blocking the Lachin corridor, chokeholding 120,000 indigenous ethnic Armenians from the outside world since last December. On the blockade of the Lachin corridor, Genocide Watch has qualified it, and I quote, as a clear attempt by the Azerbaijani government to starve, freeze, and ultimately expel the Armenians from Nagorno-Karabakh. The Lemkin Institute for Genocide Prevention issued red flag alerts for genocide, stating that the responsibility for this humanitarian crisis lies solely with the Azerbaijani state and particularly with the regime of President Ilham Aliyev. In February 2023, the International Court of Justice ordered Azerbaijan to take all measures to ensure unimpeded movement through the Lachin corridor. Azerbaijan has ignored this order. It remains in blatant violation of the ICJ's decisions to this day. These human rights and international violations fall squarely in those covered by Section 4 of Canada's CIMA and also warrant the application of Canada's Magnitsky Act. The call for sanctions against Azerbaijan have also recently been made by the following government bodies and officials. The European Parliament in March of 2023, which called on the Council to impose targeted sanctions against Azerbaijan officials for not respecting the International Court of Justice's order. The chairman of the U.S. Senate Foreign Relations Committee in May. Calls for sanctions were made by the French Senate and the French National Assembly, and by the ambassador to Armenia, the ambassador from Armenia to Canada, who gave evidence to this very committee in January. Genocide Watch and the Lemkin Institute have also called for sanctions against the Azerbaijani regime officials. Similarly, this committee should recommend the imposition of targeted sanctions on the Azerbaijani regime in order to uphold human rights, international law, and justice. Canada's laws allow it to apply specific sanctions in a balanced manner while still maintaining diplomatic relations. Without accountability, there's no justice, and without justice, there can be no peace. Le Canada a affirmé à plusieurs reprises son engagement à promouvoir.
Canada has often stated that it is committed to protecting human rights. I think that all Canadians expect Canada to continue to show a good example to protect the Armenians as they do in similar contexts for others. And I salute the difficult but crucial work of this committee, which is committed to studying these issues, among many others, in its review of Canada's application of its sanctions regime. Thank you for your attention, and I'll be happy to answer any questions you may have.
Thank you very much, Ms. Cadian. Now we go to Mr. Kiao. You have 5 minutes, sir.
Thank you. Thank you, Mr. Chair. Mr. Chair, Vice Chairs, and Standing Committee members. My name is Zokyo, a Myanmar Canadian living in Canada since 1991. During Myanmar's brief democratization period, I worked as a CEO at most successful special economic zone in Myanmar. Now currently, I'm acting as a spokesperson for the National Unity Government of Myanmar. I'm honored to have this opportunity to appear as a witness in view of the committee's study of the Canada's sanctions regime, particularly on Burma, Myanmar. On the morning of 1st February 2021, the Myanmar military launched an attempted coup against democratically elected government, halting the country's fragile transition towards democracy. Following the coup, the people of Myanmar took to the streets for mass peaceful protests. The military responded with deadly violence, killed many people, and imposed a campaign of terror, raiding homes and arresting anyone suspected of supporting democracy. Faced with defiant and widespread resistance to date, the military has been unable to consolidate its control of the country. It has deployed increasingly brutal violence to crush opposition, but people's resistance is still strong and growing. Since the military coup, over 3,600 civilians killed, nearly 23,000 civilians arbitrarily detained, over 60,000 properties, including religious facilities, hospitals, and schools were burned down. Over 1.7 million internally displaced people were reported across the country. Canada has shown no hesitation to take actions against the Myanmar military. In December 2007, the Special Economic Measure Burma regulations came into force in response to the humanitarian and human rights crisis situation in Myanmar, Burma. Canada's sanctions were one of the toughest sanction regimes at the time. Following positive development in Myanmar, Canada eased its economic sanctions in April 2012. And however, Canada still maintained sanctions against certain listed individuals and entities and arms embargo. The regulations were amended in 2018 to add 7 senior military officials who occupy positions of authority during the military clearance operations against the Rohingya in Rakhine State. Canada was among the first countries to impose new sanctions in light of February 1st, 2021 coup. Since then, Canada imposed additional sanctions 6 times, resulted in a total of 95 individuals and 63 entities. Canada is the first country to impose sanctions on Myanmar military jet fuel suppliers. Despite the sanctions from Canada and the West, Myanmar military is still capable of increasing its terror acts against the civilians. Their foreign partners and new corporate fronts are easily able to skirt the sanctions, existing sanctions. In September 2022, Myanmar junta shut down the public access to Myanmar Corporate Online Micro Corporate Registry in order to shield the shareholder information and to hide newly established friend companies. Those demonstrate the need to strengthen the current sanction regime. While I believe the sanctions are useful to pressure the brutal military, there is also room to improve Canada's sanction regimes on Myanmar to become more robust and effective. Yesterday, Nikkei Asia reported that Russian repurchases of parts for tanks and missiles that had been exported to Myanmar and India, that Russia will use those in Ukraine. So Myanmar military is now a threat to the global security. Canada and West must coordinate to target arms suppliers and brokers. So Canada has to target aviation fuel suppliers. Canada needs to coordinate with allies to ban protections and indemnity P&I clubs from providing insurance to any vessels carrying aviation fuel to Myanmar ports. Canada and democratic countries could strengthen sanctions to choke off dollars to the military by targeting junta revenue, foreign revenue, such as Myanmar Foreign Trade Bank, MFTB, and Myanmar Oil and Gas Enterprise, MOGE. I am very much concerned about the purchase of Chevron's stake in Yadana offshore gas, which Chevron owned 41% by the Canadian entity, MTI Energy subsidiary, little-known company E.T. Martin Holdings. By the way, Yadana gas field is the largest gas field in Myanmar, and then gas assets. So thank you so much. I will be happy to discuss further, and I thank you so much for giving me the opportunity. Thank you. Thank you,
Absolutely.
Mr. Chair.
Thank you, Mr. Kiao. And you will have ample opportunities to respond to questions by the members. So we now go to Ms. Moret. Ms. Moret, you have 5 minutes for your opening remarks.
Thank you very much, chairs and distinguished members of the committee. Thank you for the opportunity to testify today. I've been working on multilateral and autonomous sanctions for 20 or so years, and during this time I've explored questions of impacts, effectiveness and coordination of sanctions regimes such as those targeting Russia, Syria, Afghanistan, Iran, North Korea, and so on. I've also researched sanctions in relation to areas such as chemical weapons abuses, nuclear non-proliferation, cybersecurity, modern slavery and human trafficking, and humanitarian considerations. I also coordinate several multi-stakeholder initiatives on behalf of the European Union, Swiss Federal Department of Foreign Affairs, and the United Nations on sanctions. And in recent years, I've also provided testimonies on sanctions to the US Congress, both UK Houses of Parliament, Canadian Senate, and the European Parliament. In 2020, I provided research and strategic policy advice to Global Affairs Canada's new sanctions unit, including a suggested checklist for sanctions design and a blueprint for areas where Canada could play a positive leadership role in global sanctions fora, drawing on its unique position in the world. I'll draw on this work today, as well as the testimony I provided to the Canadian Senate in December 2022. And I'd like to share reflections on just two key areas where I feel most qualified to talk about today that relate to recommendations that this committee made in April 2017 as part of Canada's parliamentary review on Canadian sanctions, which led to Global Affairs Canada being afforded stronger capabilities and more flexibility in the area of autonomous sanctions. So the first area was the recommendation to properly resource and reform the structures responsible for Canada's sanctions regimes. An earlier criticism was that Canadian government didn't have the adequate resources to implement and enforce an effective sanctions regime, nor to allow for independent oversight of Canada's sanctions procedures. Important steps appear to have happened in the right direction in recent years through establishment of the Sanctions Policy and Operations Coordination Division, with stepped up resourcing and legislative reforms. And from my experience, this is staffed by extremely dedicated, expert and hardworking officials who have adapted well to the fast-changing global sanctions landscape. In response to earlier critiques over difficulties navigating sanctions lists, Global Affairs Canada now has consolidated autonomous and UN sanctions lists on its website, and other sites also provide useful information on sanctions resources, such as that contained in the Parliament of Canada. As I understand it, regular reviews are conducted, and Canada's also contributed to a number of detailed studies and tools that help aid sanctions design, both within Canada and globally. Another notable change has been the rise in Canada's prominence in autonomous sanctions practice in close coordination with the EU, the UK and the US in particular, alongside others. And I'll see this as something as a positive step, which responds to recommendations that closer collaboration was warranted. And this formalization and streamlining of these types of collaboration, I would say, is a merit to Canada's involvement. In light of this close working with international partners, I'll say that Canada's sanctions use is increasingly plurilateral, to borrow the term from the World Trade Organization, and really not particularly unilateral as per some critiques of autonomous sanctions, with between 30 and 40 countries working together, given the impasse that we see today on sanctions at the UN Security Council. And this allows Canada to join allies in addressing breaches of international law and play something of a leadership role in international foreign and security policy. And this also serves, of course, as a force multiplier by working together. We also see formalization in other types of collaboration, such as through the Russian elites, proxies, and oligarchs task force, which is a multilateral effort that has used information sharing and coordination to identify and exert pressure on sanctioned Russian individuals and entities. And Canada is, of course, a member alongside a number of other different countries and the European Commission. An expansion in terms of staffing, training, capacity, and resourcing, in my view at least, appears to be warranted, not only in Canada, but also elsewhere, considered the very steep rise in prominence of sanctions that we're seeing across the world today, and particularly following Russia's full-scale invasion of Ukraine in 2022. If we take a couple of examples from elsewhere, the UK sanctions unit has grown dramatically in recent times, now sitting sitting at around 160 individuals. The Netherlands has just seen the creation and growth in its own sanctions unit, and this has been happening elsewhere as well. So it gives a kind of context in terms of the need for proper resourcing across the board of different areas. And a very quick point to conclude in terms of the recommendation for Global Affairs Canada to provide comprehensive, publicly available written guidance to the public and private sectors regarding the interpretation of sanctions regulations in order to maximize compliance. Canada, of course, lacks an investigative or enforcement body of the likes of OFAC in the US Treasury. And alongside this, we know that Russia and other actors are using sophisticated evasion and circumvention techniques in coordination with other sanctions targets, not to mention particularly DPRK, Iran, and so on. So enforcement has now become the name of the game. And I think we can learn some lessons from what other countries are doing. So we've seen the US Treasury working together with the UK Treasury to develop common approaches in terms of enforcement and investigative powers. We also see the EU and US...
Ms. Murray, if I could ask you to
outreach.
conclude in the next 20 seconds or so.
Sure. We see stepped up outreach by the US and European Union, and that's also to reduce over-compliance, which has become a growing problem, particularly in relation to financial sector de-risking. But in order to do so, again, it really does require proper resourcing and capacity. Thank you.
Thank you very much, Ms. Murray. We will now open it to questions from the members. We start off with MP Genis. MP Genis, you have 4 minutes.
Thank you, Chair. I do want to just share a brief notice of motion that follows our discussions in the last hour that the committee report to the House that it wishes to see the awarding of honorary Canadian citizenship to Vladimir Kara-Murza. Further, the committee calls for Mr. Kara-Murza's immediate release, period. I know there'll be further discussions among the parties, but I want to just put that on notice to give options. Ms. Kadian, we've talked at this committee about the importance of reopening the Lachen corridor. We have called for that. The committee is waiting for the government to respond to a report to the House on that. Hopefully that response will be forthcoming very soon. What kinds of targeted sanctions specifically do you think would affect or increase the chances of bringing about the reopening of the Lachen corridor?
Thank you for the question. The types of targeted sanctions that would be useful, I think, would be towards regime officials who are implicated in the blockade. So those who are directing these acts, those who are operating on these acts. These types of sanctions can be on individuals. It can be very specific. It can also, I think, send a very strong message because... Yeah.
Sorry, if I could just jump in. I mean, my understanding is that there's a bit of a Mickey Mouse game that's gone on where people have said, "Oh, these are environmental activists. They have nothing to do with the regime," and I mean that's obviously not credible. But does that complicate your proposal of targeting regime officials, or do we know, or can we know externally who the people directing these things are?
I think there's open source information from different organizations, from different partners, from the International Court of Justice's order that is actually qui vise is ordering the Azerbaijani regime to open the corridor. So the Lemkin Institute, the Genocide Watch, NGOs have also all called upon this regime to open the corridor. So I mean, if there's information that's muddying the waters, it's not coming from these. It's coming from uncredible sources, I would believe.
Thank you. I want to move on to another witness, but if you could provide some follow-up written information with specific names, specific individuals, specific institutions that you think should be sanctioned with that particular goal in mind. Mr. Kya, it seems clear from your testimony that the sanctions that have thus far been implemented against Burma have been ineffective. I wonder if you would agree with that characterization, and if you can share a little bit more about how we can specifically close the gaps through our sanctions regime, and then also, if there's time, also speak to collaboration between the military junta and Russia, and how gaps in sanctions may be a mechanism by which certain materials are making their way to Russia and being used in the invasion of Ukraine.
Thank you. The regime junta's military is increases in attack on the civilians. For example, using the fighter jets and helicopter gunships, attack the civilians. And last year alone, almost 600 airstrikes against civilian targets. Those were supported, planes were supported by China and Russia. And Canada sanctions, like Mr. Jiu mentioned, the Canada sanctioned the aviation fuel suppliers, but they skirt around the sanctions. So Canada and allies should use that protection indemnity club to ban the insurance to support to the vessels supplying aviation fuels to Myanmar. Myanmar military 100% rely on jet fuel, rely on the imported jet fuels. So if you cut off that, it will protect civilians' life. And then now that Russia is in trouble because of the global sanction against their arms sanctions, so they use Myanmar to buy the arms, purchase the arms. So the parts, now that report is the parts for the tanks and the missiles, and then Myanmar re-exported to Russia. Then the Russian can use in Ukraine. So that's a recently released report, but it's been doing it for months now. So that that's why that Canada and allies should close the gap, sanction against the arms brokers, and so this way that we have all the arms broker lists that we can provide, and then also that the military regime, the biggest single source of revenue came from the oil and gas sector, and so Myanmar oil and gas enterprise alone, $1.5 billion. So Canada and West could sanction MOGE, Myanmar oil and gas enterprise. Thank you.
Thank you. We now go to MP Zuberi. You have 4 minutes.
The witnesses for being here, and Mr. Kyo, I hope I pronounced your name correctly. I'll put most of my questions to you. I know that you are the spokesperson for the National Unity Government in exile for Myanmar, and that you are responding to the military junta in Myanmar, and I think that that's important. What we're hearing from you, that response. I'd like to ask a few things around some policies of the National Unity Government, which I know includes Aung San Suu Kyi's party and other ethnic minority groups and other minority parties. With respect to the Rohingya, what is the position of the National Unity Government?
Thank you so much. I just want to point out that National Unity Government is not the exile government. Actually, the acting president and prime ministers and many of the ministers are working inside Myanmar. And then also that National Unity Government, even though NLD members, including NLD members, are minorities, less than 50%, 46% are NLD members, and then over 50% are representing different ethnic groups, and then also the NGO groups as well. So acting president is a Christian ethnic minority, Christian, and then also prime minister is a Korean ethnic. To answer your questions, the National Unity Government Minister of Human Rights presented to the UN Human Rights Council, presented a paper, and then also the National Unity Government released a Rohingya policy paper. That's clearly said that the recognition of the citizenship rights for the Rohingyas, and then also that return to their home, villages and homes to the dignified returns, and also that the Rohingya representation in the NUG government also work in progress. And another thing is that indiscriminate law, citizenship law, that NUG cabinets make the decisions to repeat and replace with a more democratically, internationally acceptable law. That's a law that discriminates against Rohingyas and other ethnic minorities. So that's a basic things that the NUG National Unity Government is working. And then also that for example, right now, the cyclone Mokas landed in Arakan states. Most of the casualties are Rohingya refugees. So that's also that we are supporting those refugees through the civil society, local civil societies. And this is how our governments will work for equality and self-determination, including for the Rohingyas.
Thank you. And a follow-up to that, I guess you have answered how you'll look to include diverse groups into a future government. Do you have any further comments on that particular point, how to include groups into a future government, including the Rohingya?
Now is that the NUG's government is that interim government, and then that will be the transitional government will be formed after the transitional constitution is approved by the People Assembly. So, and then even this NUG's government, interim governments, and then we working towards the Rangers communities, and then we will include the Rangers in our cabinet, and then also in future that will be the transition. That will be transitional governments will be more inclusive. By the way, this government is the most inclusive government in Burmese history. Burma has a majority ethnic in Burma, with about 70% of populations. But in NUG governments, Burma ethnic peoples are only about 40%. And over 60%, almost 70% are non-Burma ethnic. But still, we still need to include Rohingya people in the cabinet. That's what we are working towards with the Rohingya communities as well.
With respect to the refugee crisis?
So we will now go to the next member, which is Monsieur Garon. You have 4 minutes.
Thank you, Mr. Chair. I will put my questions to Ms. Moret. In December 2022, you stated to the Senate Committee of Foreign Affairs that the methodologies and tools used to measure the effect and efficiency of Canada's autonomous sanction system didn't exist. Earlier today, I asked the following question of a witness, whether the asset flight had been quantified. So, to you, I ask, do these sorts of measures exist elsewhere? Are they used appropriately elsewhere? Where's Canada? And if we're not far enough down that road, what type of mechanisms should we consider using? Yes, thank you very much for the question.
English. I think that this is a challenge that's faced by all of those who are making use of sanctions autonomously, and also in the United Nations as well, that mechanisms or tools in order to assess the effectiveness and impacts are not very well developed yet. Nevertheless, there are methodologies out there that could be adapted should those states wish to do so. But I think in the absence of this, it's quite hard to make with any confidence a kind of accurate assessment of the actual impacts of sanctions that they're having. But as an aside, it's also incredibly difficult to do so methodologically when it comes to proving causation over correlation, because of the fact that there are so many complicated factors going on in any one context, particularly those where there is an armed conflict underway, or in contexts of humanitarian emergencies as well.
All right, I understand that the methodology can be complex, but to improve our ability to evaluate the effects of our sanctions could help a country such as Canada, avoid undesirable effects, unexpected effects of its sanctions on civil populations, for example, and asset flight.
There are certainly lots of things that could be done, and that could draw on methods that have been developed elsewhere. But I think there's also, in parallel to that, there are some really important things that Canada could be doing, and I believe has already started to do. The first is to create something of a tri-sector group within the country. That would typically be between the governments, those designing the sanctions, regulators and so on, but also NGOs, banking sector, wider private sector and so on, and to meet regularly. And that has been very important in other countries, to allow for regular exchanges with relevant stakeholders that can be kind of flexible, respond to changing situations on the ground, and allow for policy change where needed as well. And then I think engagement in international fora is also really critical here, because we have now 10 or more years of really excellent studies and multi-stakeholder dialogues that have generated recommendations, and some of the solutions are out there.
Ms. Moret, I am going to politely interrupt you simply because I have little time. And yes, on sanctions, Canada rarely works alone. We're a multilateral country. But you have suggested that Canada might make more formal its strategic coordination and planning. So what would that look like? How would we make these channels more official and institutionalize them?
Well, I think to an extent this has already begun with some of the coordination that's happening on the Russia sanctions, and a lot of the time, my understanding is some of the relationships or mechanisms are quite informal in nature and perhaps depend on individuals who are in certain positions, and then when they move on, some of those links need to be recreated. But I understand that now the exchanges and interactions are particularly regular and much more coordinated than they used to be. But I think, given the fact that in all likelihood, the sanctions that we see moving forward coming out of Canada are going to be planned in very close collaboration with the three actors I mentioned already, UK, US and EU, and likely a host of others as well, Australia and so on. I think the more mechanisms and formal kind of processes that can be in place to allow for joint planning, monitoring, and so on, sovereignty concerns notwithstanding, I think the better when it comes to effectiveness of the measures.
Thank you very much. We now turn to Ms. McPherson. You have 4 minutes.
Thank you very much, Mr. Chair. Thank you for being here to all of our witnesses as well. Ms. Murray, I'm going to continue on with the questions that my colleague has just been asking you. We've added a number of names to our sanction list. As you mentioned in your testimony, the increase in the use of the sanction mechanisms has skyrocketed around the world, and I think obviously what's happening in Ukraine is the reason for that. But of course, adding the names is not the same as enforcing the sanctions, and it's not as useful if we don't have those enforcement mechanisms. So, in Canada, the RCMP's reported that approximately 136 million in assets have been frozen, 292 million in financial transactions have been blocked. I'd like your perspective. How would you evaluate how we are doing with regards to enforcement, and what are those exact key things that we need to do to make sure that the enforcement of the sanctions is equal to the adding names to lists of the sanctions?
Yeah, absolutely. I think it's a huge challenge elsewhere, not just in Canada. But I would say that, first of all, Canada doesn't have the investigative or enforcement capabilities that the Office of Financial Asset Control in the US Treasury does. And if you think there, the staffing is into the hundreds of people, and the sophistication of the techniques they use have also been honed over many, many years. So I think that is the first point, that having a proper ability to conduct investigations and to engage in enforcement is critical. And at the moment, I believe that all of this is done, decisions on new sanctions, outreach to private sector, investigations, it's all done by a small group within Global Affairs Canada, and they simply can't do everything. And I would say that really does warrant some closer capacity if that is to change. I think another lesson is that working with partners is really key, and it's not for no reason that we see the special envoys of the US and the EU, Jim O'Brien and David O'Sullivan, working together to encourage third countries to clamp down on circumvention, or not to at least support evasion and so on. And I think that is also key, working with international partners. And a final point I would make is that capacity in third countries is absolutely critical. And many of the countries that you would hope are helping not to fill gaps, or at least to help enforce the sanctions, may be really lacking in capacity. And that's not just in the government departments, but it's also customs, the intelligence services, policing, and so on. So it really does need to be some very serious capacity building efforts overseas that could be done collectively with other partners, in my view.
Thank you very much. Well, it sounds like, what you're telling us is that there's some capacity building that needs to be done in Canada too. When you talk about hundreds of people working on this work, whereas I think we heard that we had 7 or 12 or some very small number working in Canada. I think resources is a key priority. I'd like to ask a quick question from our witness from Myanmar, Burma, if I could. You spoke a little bit about the arms and the Myanmar military. Could you talk a little bit about how Canada could better ensure that all arms, including Canadian parts and dual-use systems, don't make it into the hands of people or governments under sanction?
Yeah, thank you. Yeah, it's it's very unfortunate that the parts and supplies still going to the Myanmar military, including from the West. I'm not sure about the Canadian arms are there, but from Europe and the U.S. companies directly or indirectly providing it. So that's why that we need to target the arms brokers. They're using the different channels, the arms brokers, not only the arms suppliers. So this way that Canada need to coordinate with allies and then target the sanction against those arms brokers. This will ensure that junta will not receive the parts or arms to kill the people and also re-export it to Russia to kill the Ukrainian people and also Russian people.
Well, thank you very much, and I believe that's all my time.
So we now go to the next round. We only have 3 minutes per question, and we start off with Mr. Jenis. 3 minutes.
Thank you, Chair. Mr. Kya, I want to follow up on your comments about arms brokers. Would you be able to provide the committee with an in-writing follow-up with some names and details about who the particular arms brokers are and how they can be sanctioned?
Yes, I can provide it after that. Yeah.
Okay.
And then some of the brokers are already sanctioned in the Canada and the U.S., but many more are still out there. And then those existing sanctions, as I mentioned, they evade the existing sanction as well.
Thank you. Just in a minute or so, could you elaborate more on oil and gas sanctions specifically, how we should do those, how they can be targeted, and what's effective?
Oil and gas sanctions are more vulnerable to the Myanmar military. And yes, we did a lot of sanctions from Canada. Many of them are symbolic, but Myanmar oil and gas enterprise make revenue alone $1.5 billion. So the single source of income for the foreign exchange income for the Myanmar military. So this way that EU already sanctioned the Myanmar oil and gas enterprise, but for my fellow witnesses say that it has to be coordinated and that they're using the different loopholes so that Canada, US, EU, and should sanction against oil and gas, Myanmar oil and gas.
Yeah. So in terms of your discussion about loopholes, is the problem that sanctions are supposed to be applied but are not being effectively enforced? Or is the problem that we're sanctioning some entities but we're not sanctioning others, and effectively the entities are able to use legal means to bypass the sanctions by engaging with unsanctioned entities?
Yes, this the other way around. And for example, Asia Sun Group, they are the arms broker, arms suppliers. Canada and the West already sanctions, but our information said that they have another front companies called Shun Energy entity, and that one still using the Shun companies is the one that who imported the arms.
Right. So I guess my question is the use of these front companies, is it formally illegal? Is the circumvention being done through legal means or illegal means?
We don't know.
Okay.
That's mean it could be illegal because of the sanctions. They bypassing the sanctions. That's the illegal.
Thank you. Just quickly in the time I have left, Ms. Kadian, I wanted to just ask sanctions against your thoughts on Turkish government officials that may be involved in violations of human rights around in the conflict between Armenia and Azerbaijan. Are there officials affiliated with the Turkish regime that you'd recommend for sanctions as well? And if you have thoughts on that briefly, or could follow up in writing, that'd be great.
Very briefly, under 15 seconds, please.
So there are obvious links and supports that are happening from Turkey to Azerbaijan in creating this human rights crisis. So we can provide other names as well afterwards.
Thank you. Now we go to Dr. Fry. Dr. Fry, you have 3 minutes.
Thank you, Chair. I want to thank the witnesses for being here. And I am particularly concerned about what Ms. Moret has pointed out, even though it would seem to be difficult. If sanctions are going to work, we can't evaluate what the impact of it has been. It looks like in Myanmar we haven't changed anything. really, things are worse. Do we have indicators that we can use, for instance, to measure, to look at how we're getting to where we want to go? What happens if you've sanctioned a country and that country continues to escalate its behavior against human rights, etc.? How do we know if that happens? How can we, for instance, look at loopholes? So if we don't have indicators and we can't measure, we can spend tons of money trying to do something that in fact has no impact. How can we, do you know any country that has developed at least a set of indicators, some form of benchmark measurements that we can use to at least, even if crudely, evaluate what's going on?
Thank you very much for the great question. I would say that all governments are most likely using a set of internal benchmarks of kind. Whether or not they're kind of a very comprehensive established methodology is another question. But I would say that there are certainly ways we can start to think about different types of impacts. And that's for me the key question, that there's not just one type of impact. There's the signaling, political function of showing something decisive is being done, of course, but there's also constraining access to key resources. And I think we can see that very clearly in Russia at the moment. The fact that Russia is having to purchase ammunition shells or rockets from the DPRK or drones from Iran suggests that they're really having to go to great lengths now to access some of the dual-use goods that are otherwise hard to reach.
Thank you, Ms. Murray. I don't have a lot of time, and I would like to ask a further question. So, first and foremost, are there other countries that have established certain indicators and ability to measure? That's the first part. The second part that I really wanted to get to is, should we expand sanctions to countries? Are we already sanctioning Myanmar? But should we expand sanctions to countries that are being used as funnels by countries that are already sanctioned? How do we do that? How do we know that that's going on?
I think when it comes to your question on other countries, the key here is that there are various initiatives underway in the US, in the EU, as far as I understand it. And I know that Canada is closely involved in some of those discussions as well. So I think that's a very positive thing. With regard to your question on sanctions on countries that are serving as a kind of funnel, this is definitely being discussed elsewhere at the moment. And that's the purpose of US extraterritorial sanctions, of course, in many cases. And I think that would be probably a big step forward for Canada to start to enter into that terrain, given the kind of long-standing opposition alongside the EU to those kinds of measures. But at the same time, there are other ways, in my view, to work together with other countries to ensure that circumvention and evasion is clamped down on. I think ultimately, with the idea of changing a behavior, that's something that is less likely to come about with sanctions, but really constraining access to vital resources such as weapons, financing, and so on. That's a much bigger success story for sanctions in many cases, I would say.
Thank you for that. Now we move to Mr. Garon for a minute and a half.
Merci beaucoup. Thank you. I will continue with you, Ms. Moret. In a recent article in La Presse, you brought up the Americans' Foreign Control Office and it being well-staffed. They're able to investigate and follow up on the effects of sanctions, on the application of sanctions. So what's the difference between their office and the way we operate up here in Canada? And what could Canada learn from the Americans?
So thank you very much for the question. I think first thing is to learn what not to do, because I think what we've seen happening with US sanctions in the past 10 years or so is a consequence which has been over-compliance and financial sector de-risking. And that really has very broad-ranging ramifications that go way beyond the intended functions of sanctions. So I think a first lesson is to find a very delicate balance between compliance, and that means ensuring correct compliance, and then not falling into the other side of the scale, which would be over-compliance. But again, I come back to the point that OFAC depends on hundreds of people, and also that extends to other government agencies as well, where there is an extremely close working relationship, as I understand it, between different government departments within the US. So I think that again is a really key issue of working together with others members that play different roles, and we see that that's not always the case when the decision making, or at least the responsibility for enforcing sanctions, falls to one particular part of government. It's really vital to be working across the board as well.
Thank you, Ms. Murray. For the last minute and a half, we go to Madam McPherson.
Thank you very much. This has been very interesting and very informative. So thank you to the witnesses for being here for us. One of the things that I'm picking up on, Ms. Murray, from some of your testimony is just the need for clarity, for transparency, for that currently that it's a bit opaque on how people are selected to be put on the list, how those are being enforced, what that looks like. I'm wondering whether or not you could talk a little bit about best practices, what Canada could do to ensure that civil society is engaged, to ensure that diaspora communities are engaged, just to ensure that it is a more transparent and effective system.
Yeah, thank you. Absolutely. So this is very much the focus of my work elsewhere. And I think the first point is to have regular interactions, regular dialogue in a way that can be done in a trusted fora where kind of almost a common language is established, because it really does take time. My experience has shown it can take a number of years to kind of build up the trust that's required for different sectors to be communicating with one another effectively on these kind of delicate topics. And I think that's the first point. And that can be including representatives of groups of NGOs as well, as a way of streamlining some of this type of interaction. And the same should also apply to, of course, banks and also the wider private sector in terms of things like trade, global supply chains, and so on, where Canada's played a role. The second area, I think, is thinking about harnessing some of the technology. In Canada, you have a fantastic fintech sector, fantastic innovation, and I think there's lots that could be done to harness some of the positive sides of tech in terms of helping to bring down due diligence obligations and help increasing transparency, even facilitating humanitarian fund transfers and so on. And the third point, I think, is to have a point of contact where NGOs, civil society and so on are able to get in touch when they have questions, the same for banks and so on, when they have when the nature of permissible activities isn't clear to them, where wording may not be clear and so on.
I believe I'm out of
That concludes our questions. Allow me to thank Ms. Cadian, Mr. Kiwa, and Ms. Murray for their expertise. As you could tell from the members, your session here today was very, very helpful. But before I adjourn, just wanted to let the members know that today we dispense with the 10 minutes of business for the committee, because everyone did agree to make some changes to the schedule. So it was agreed by all the members that for the remainder of this session, we will be focused on sanctions regime, with the exception of next Tuesday. Next Tuesday, for the first hour, we will be hearing from government GAC officials regarding the Wagner Group. And then for the second hour, we will be hearing from the Lithuanian Vice Minister of Foreign Affairs as part of our ongoing study on Ukraine. So that's for next Tuesday. Also, given the change in the schedule, we are now moving back the submission of recommended witnesses for our Wagner Group study to next Tuesday by end of day. So, yes, did anyone have any questions? All good? Okay, adjourned. Thank you.